Thank you for watching my channel. This is the Boss Lady Trucker coming to you with another episode of These Attorneys Aren't Perfect, They Just Unprofessional.
The firm remained the same as far as other employees, Mr. Wade, Mr. Campbell, as the named partners of the firm. You were the one who left, correct?
That is correct.
And you termed it as a disagreement. You recall answering questions as though you left due to a disagreement. Yes?
Yes.
And that disagreement was that there was an allegation of sexual assault by an employee made against you, correct?
That is incorrect.
There was not an allegation that you sexually assaulted one of the employees in the firm.
That is incorrect, but yes. Yes.
Yes, there was an allegation that you sexually assaulted a member of the firm, correct?
Yes, there was an allegation, yes.
And as a result of that allegation, you left.
I did.
And you were no longer business partners with Mr. Wade.
That is correct.
The firm remained intact, and in fact, the employee involved remained with the firm, correct?
I'm not certain of that. They did leave the building, of course, and I don't know. Some employees did leave.
Were there two incidents where you sexually assaulted this employee?
No, I didn't sexual assault anybody.
Was there another occasion where you paid any money as a result of an allegation of sexual assault against you?
No.
Did you sexually assault any clients of your firm?
No.
Never?
Never.
Who's Anna Rodriguez?
I don't even know their name.
You don't recall a client named Anna Rodriguez?
Anna Rodriguez? No, I do not.
Never met her?
I do not recall the name Anna Rodriguez.
Pardon me, Your Honor, I would object to this. I'm not sure what we're trying to do here. So I would object to this one.
All right, Ms. Cross.
Your Honor, this clearly goes to the bias that the witness has towards Mr. Wade and other individuals, his motive in involvement. And I believe it's an appropriate avenue to pursue based on exploring his credibility.
So, just a few preliminaries. First of all, I'm a bit under the weather, so I'll try to speak up, but if anyone can't hear me, just let me know. I'll try to talk closer to the microphone. But we are here today, the sole purpose of which is that at the conclusion of the hearing on February 16th, I announced that I'd be meeting with Mr. Bradley in camera to assess the validity of his assertion of attorney-client privilege. I've now been able to do that, and I also allowed Mr. Wade the opportunity to weigh in and respond as well. And after considering the testimony, not only in camera, but also what came out at the hearing, I found that neither Mr. Wade nor Mr. Bradley had met their burden of establishing that the attorney-client privilege applied, specifically as it relates to Mr. Bradley's knowledge of any relationship that existed between Ms. Willis and Mr. Wade, and particularly that it wasn't established that his specific knowledge came about in furtherance of legal advice. So having made that determination, I didn't see any other choice but to allow the parties to have an opportunity to explore that topic with him. There's really, in my mind, it's that topic only. I think if there's anything else we've already covered, I'm not here to do it again. Mr. Bradley, Deputy Staff Surveyor again. I do.
Terrance Bradley, Terrence Bradley, Bradley, Bradley.
Ms. Merchant.
Thank you, Judge. Good afternoon, Mr. Bradley.
Good afternoon.
Good to see you. Sorry, under these circumstances. I'm going to just go straight to where we left off before. Fani Willis and Nathan Wade were in a romantic relationship, correct?
Correct.
And it began at the time that they were both municipal court judges, correct?
Objection, Your Honor, based on privilege. That was covered in the attorney-client privilege.
Okay, overruled.
I do not have knowledge of it starting, or when it started.
Terrance, you told me that it started when they were both municipal court judges, though, correct?
That is incorrect.
You never confirmed in writing that it was, instead of magistrate court, it was in municipal court judge when they started dating?
If you're speaking of the text message, you can go to that text message and you can read that text message, and I will explain the text message to you. But you and I did not have a conversation about when it started. You asked a compound question of magistrate court versus, you said it was magistrate court, you said magistrate court conference, I'm sorry. And then you asked another question. I said, no, municipal court, nothing else.
I'm referring to a different conversation. I asked you, do you think it started before she hired him?
And I'm going to object. This was covered in the previous hearing where Mr. Bradley said he had no personal knowledge of the exact text that Ms. Merchant is speaking of and actually used in an attempt to refresh his recollection. And he explained exactly what he's explaining before the court. So this is repetitive and unnecessary. So I would object to asked and answered and irrelevant to this point.
Perhaps we'll get there, but I think first Ms. Merchant has the right to draw his attention to the exact, potentially inconsistent statement.
Thank you, Judge. May I approach him?
So overruled.
This is
You may.
the text I can use. So you can see. Someone ready to blast her.
And for purposes of the record, I believe Ms. Merchant, you tendered, was it the entire text chain as an exhibit?
I only tendered a few of the texts, but I did give the state their courtesy copies last time of the exhibits.
Was this one tendered?
This one was not tendered.
All right.
And I'm happy to tender it.
Well, we'll just take it as it comes. Whatever you
We're at, I think we're at 39. I will wait to mark it, but I think we're at 39. May I approach you?
You may.
So Terrance, do you remember telling me that it started when she left the DA's office and was a judge in South Fulton?
I see the message there, but I don't recall. I do see that message, but I do not recall.
You don't recall texting this?
I look back at my text messages through that we've had. I see that message, but I do not recall that. Ma'am.
And when I asked you if you thought it started before she hired him, and you responded absolutely.
Your Honor, I'm going to object as to the source of the information that Mr. Bradley allegedly gathered this from. There's been absolutely no foundation, and based on the arguments of the last hearing, that a lot of this is based on gossip, innuendo, assumption, and privileged information. And at this point, Ms. Merchant has not provided a foundation as to how Mr. Bradley would have any information that she keeps referring to.
All right. I think that's, go ahead, Ms. Merchant.
I didn't ask him about the source of the information. And under Rule 621,